Analysis now in our studio here in New York from trial attorney Robin Nunn. Welcome back, Robin. I want to go to the jury instructions that Caitlin was talking about. If we look at the tablet I have, and we can project this up onto the screen, a charging conference is a meeting between a judge and lawyers to develop the jury charge. And if you read through that, what I want to focus on is kind of this part right down here, the jury charge itself, the judge's instructions to a jury about the law, its application, and the weighing of evidence for deliberations. A lot of minutia, a lot of legalese, but in this case, we're told this is really, really important. Why?
Yeah, I think that it is. This is obviously already sort of a blockbuster, compelling case, like the trial of the century almost.
Yeah.
And the jury charge and the jury instructions are something that each and every one of those 12 individuals has to comprehend and understand, because it's not just a run-of-the-mill case here. While
almost two crimes in one, right? And is there a possibility, or would you be concerned as a lawyer that the jury or a juror would have trouble kind of understanding what they're being tasked to do if it's not explained to them the right way?
I completely think that it will be difficult. While many have described this as a very simple case, just a sort of hush money falsifying of business records, 34 counts, it's a lot more deep than that. There's an element of intent. There's an element of, crime, falsifying business records. And it involves, obviously, the former president of the United States and potentially the next president of the United States.
And it needs this second crime, we're told, this underlying crime that we presume, we'll hear about this, I would think, next week in the closing arguments, would have something to do with election law. So this was guy Brad Smith, who the defense was considering calling an election law expert to testify, but they decided not to. Again, back to the tablet here, he had this flurry of posts on X, like a thread of posts where he talked about how the judge had so restricted his testimony that the defense decided not to call him. And as I hit this, we'll start to scroll through because it was one post after another, but he was an election campaign expert. He says this kind of thing could be complex. He even mentioned Antonin Scalia not understanding it all the time, and how a jury in a case would have to try to figure out this complex type of thing. What he says, is I'll pause it right here for a moment, is that what he was going to do, and this is in this particular post right here, bring something specific to the jury. Someone has to bring the knowledge, he says, and that, not the law, was his intended testimony. For example, part of the state's case is they wrongly reported that they knew what they knew to be a campaign expenditure in order to hide the payment until after the election. And as you and I talk about this, I'll let the scroll continue here for a moment. How about how Cohen testified they wanted to get past the election. But he talks here about reporting schedules, and he says, pause it once again, they thought it was a campaign expenditure to be reported on October 27th. But under the law, wouldn't be reported till December 8th after the election. So that kind of thing, even me reading it, I'm saying, boy, I'm getting into the nuts and bolts and minutiae here. But as a juror, I would need to kind of understand, is what he's saying, does that make sense to you in terms of how the election law should be applied?
I think it's something that Judge McShane considered, his testimony, what he wanted to present to the jury, and ultimately decided it was outside the scope of this trial.
Why do you think so?
I believe that he's trying to keep this very, very, very narrow, and he does not consider this to be a campaign finance election law case, that this is something that the jurors can work through.
Doesn't he need it to be, though, again, to get to the felony level? Doesn't it need it to be that type of case, or no?
It does have to have an element of another crime, but and then in this case, obviously, the allegation is election interference, but the judge made the call that what the prosecution and the defense were putting forward through the 20-plus other witnesses and the hours and hours of testimony was more germane and more relevant than what Brad Smith wanted to testify to.
What this sort of was interesting that they didn't go to that testimony. Now, if we go... Thanks so much for watching. Just go to joinnn.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.